in session. God save the United States of America, the state of Tennessee, and this honorable court.
Good morning. Before we start, just a quick thank you to the lawyers for participating in this process. Mr. Hivner and the IT people from the AOC have done a wonderful job as far as working us through this, and we don't anticipate any technological problems, but if we have any, we'll just take a deep breath and pause till we work through it. Mr. Hivner, call the case, please.
In re Hadley R.
We'll hear from the appellant.
Good morning, Your Honors. I will have to say this is a little awkward. I'm not quite used to doing hearings with on camera, and I tend to move around, but I'm working to change that habit. So after 30 years, it's a little hard.
Believe me, we understand.
I'm here today on behalf of Ms. Bowman, the appellant in this case, the mother of the minor child Hadley. And the case law has been set forth very clearly in both briefs. And so instead of spending my time there, I want to spend some time going over the facts of this case with the court. Because as the court's well aware, each one of these cases must be considered individually with the circumstances of the case. In this particular case, Hadley was born in 2016. She lived with her mother up until April of 2016. Ms. Bowman was involved in an accident and was charged with DUI and was jailed at that time. Hadley's father's sister took Hadley, but because of work obligations could not continue to keep her. And so my client's family got together and made a decision as to how Hadley would be cared for. And Miss Davis, who is my client's aunt by marriage, former aunt by marriage, filed a petition in juvenile court for the custody of Hadley, and that was granted. It wasn't, my client did not object to that. She realized that there could be a situation Hadley would need care, and she wanted somebody to be able to do that for her. Additionally, she realized that she had some issues she needed to work through and wanted to make sure Hadley's best interest has been forefront for Miss Davis from the time she was an infant. Miss Davis did obtain custody of Hadley, but she was not the only caregiver for Hadley. My client's aunt, Melissa Fugit, kept Hadley from Sunday through Wednesday, even in the evenings, all night. Miss Davis had Hadley from sometime on Wednesday until she returned her to Miss Fugit on Sunday. My client's grandmother, Miss Corner, did keep Hadley during the day on Thursday and Friday up until Hadley was around 20 months old. So clearly this was a joint effort by the family members to care for Hadley. This continued as far as with Miss Fugit and Miss Davis up until about a month before the trial in the Chancery Court for Campbell County, when Miss Davis decided that Miss Fugit would no longer be keeping Hadley overnight. As the court's well aware, this is a two-prong analysis that has to be made. First of all, is there grounds for termination? And even if the court finds there's grounds for termination, what is in Hadley's best interest? As I mentioned earlier, I'm not going to go through each and every argument, but I want to point out some of the facts because I think those, the court's got to consider those in reaching its decision and what is in Hadley's best interest. The trial court found that there was a failure on the part of my client to support and to visit with her child during the 4 months preceding an incarceration. That my client was incarcerated from, I think, around October of 2018 until the summer of 2019. So the court looked at the May, June 2018 until October timeframe. And my client admitted that she did not see Hadley during that time. However, if the court looks at the total facts of this case, she didn't see her during that time because Ms. Davis had already decided she wasn't going to allow my client to see Hadley and basically refused those visits prior to that point. A turning point in this case appears to have been in February of 2017. Ms. Davis did allow my client to come and spend the night at her home to watch Hadley for 2 or 3 hours. It's the facts of what happened are set out in the record. Miss Davis left. My client was asleep. She didn't wake her, but regardless, she left. My client didn't wake up. Miss Davis returned home about an hour and a half after she left, and my client was still sleeping, and Hadley was awake and upset. The reason I want to point this situation out, obviously it wasn't the best of situations, but that happened in February of 2017. The final order from the juvenile court in Campbell County, which had the jurisdiction of this case at that time, went down in, I think it was signed in April, not pro-tunc to March of 2017. And even after that event, the juvenile court judge allowed unsupervised visitation. And I think that's key. The court has to recognize it was unsupervised visitation, not supervised visitation. Now, it was in Miss Davis's discretion. And I don't want it to appear that I'm trying to attack Miss Davis, because that is not my point and purpose here today. But there's some facts that this court has to consider. First of all, with regard to the visitation, the court indicated in its order that if my client showed proof of complying with a drug and alcohol program, that was one of the things that she was to show. She attempted to show that, but Miss Davis refused to accept her drug screens that she provided to her. Miss Davis said she wanted to see, I think, months of clean drug screens. That's not what the order required.
Counsel, let me ask you, did the trial court find that, excuse me, that mother in no time presented petitioner with any proof of her compliance, excuse me, of her compliance with her alcohol and drug treatment? Was that one of the findings of the trial court?
I can't remember specifically if that was one of the findings, but I think Miss Davis even admits that my client brought a drug screen to her place of work. She says she did not accept it because that could be false. She didn't say falsified, but manipulated, I guess, is a better word. But my client testified she brought a drug screen, and I think Miss Davis admitted it too. You know, one of the things that, back to regard to Miss Davis and allowing my client, whether or not she would allow her to see Hadley, you know, at the trial court level, my client was asked, why didn't she provide hair follicles or nail bed samples? And the reality of it was she was never required to do that. That wasn't a requirement that was placed, you know, on her. I think what is clear that Miss Davis didn't intend for my client to develop a relationship with her daughter. You know, by her own admission, my client will tell you that she has struggled with drug addiction for quite some period of time. However, by the time of the trial of this case came about, Scarlett had been sober for over a year. She was doing the things that she was required to do. She had a full-time job. She'd gone to parenting class. She was attending AA or NA classes. She was going to her probation. She was having drug screens, and she was doing what she was required to do. Now, I understand this was not during the 4-month time frame before she was incarcerated. However, if the court is looking at the best interest of Hadley, there's not more that you can ask of her to do. She battled her drug addiction. She came through that. She's been making every effort to become the parent that Hadley needs. Now, she did not ask that this child suddenly be taken away from Miss Davis and just put into her full-time custody, but what she has sought is to maintain a relationship with Hadley, which would be in Hadley's best interest. You know, I noted in Ms. Davis's, can't remember if it was in her brief or if it was in her testimony at trial, that she stated there was no excuse for a parent not to see their child. And I have to say that seems disingenuous at best, because she clearly was not going to allow my client to see Hadley. One of the things that struck me too is the fact that the juvenile court allowed unsupervised visits, however, Ms. Davis wouldn't even allow supervised visits. I mean, it was like we had one extreme or the absolute other. She admitted that my client reached out to her multiple times after she was released from jail in the summer of 2019, and she refused to respond to her. She wouldn't respond to her text. She wouldn't respond to her phone calls. So I think when the court looks at the totality of the facts of this case, you'll see that it's definitely in Hadley's best interest that this termination be overturned and she be allowed to continue to know her mother, her biological mother. Thank you.
Thank you, counsel. You have your time for rebuttal. My computer is telling me all sorts of things here, by the way, which is all. Okay. All right, we'll hear from the appellee.
All right. May it please the court. It's my first time appearing for the Court of Appeals, so it's a little different to have to do this via the computer. But my name is Adam Bullock, and I represent the appellee in this matter, Christy Davis. The appellant essentially appealed all 4 different things from the trial court. They say that the trial court erred in finding that clear and convincing evidence existed that the mother willfully failed to visit her child, that she willfully failed to her child, and that some of her conduct in regard to the child would be wanton in disregard for the child's safety and welfare. And then lastly, they appeal that the trial court found that this termination was in Hadley's best interest. And as counsel stated, I think we are kind of stuck with a 4-month time period preceding the filing of the petition. However, as it pertains to Ms. Bowman, that 4-month time period is a little different because, and it's undisputed that time period was from June the 5th of 2018 until October the 5th of 2018, which is when the appellant entered jail in the Campbell County Jail and ultimately pled to that offense in May of 2019. The appellant wants this court to believe that she was never given the opportunity to parent this child, whether it be supervised, unsupervised, or otherwise. That simply is not the case. The appellant's own testimony is that she asked for no visitation for 4 months prior to 4 months prior to her entering the Campbell County Jail. And the appellant also wants this court to believe, in our opinion, that she was just given outright unsupervised visits. That's not what the juvenile court order said. It says that she was given unsupervised visits, prong 1, at the discretion of the appellee, my client, Ms. Davis, and 2, upon them being in compliance with alcohol and drug treatment. Barging into my client's workplace with 1 urinalysis drug screen is far from being compliant with alcohol and drug treatment in our mind. She just simply did not do that because it was in the discretion. She could have come back with multiple tests. She could have submitted a hair follicle test. She could have done anything, but she done nothing. There was testimony at the trial court that my client was told either by the appellant or somebody else that she was in some sort of treatment in La Follette. Can you hear me okay, Judge?
Yes.
Okay, sorry. Yeah. And that she was in some sort of treatment in La Follette, but there was nobody submitted a letter of compliance or attendance. Nobody submitted a certificate of completion or anything otherwise. And I do want to talk about the times that she was given an opportunity to parent this child. Specifically, I want to focus on that February 2017 date that the appellant wants to focus on. My client approached the appellant and said, do you want to exercise an unsupervised visit? You can come up to my house and stay overnight. And in the morning, you can get up and get Hadley ready. And I'll go on and go to work. And then at sometime thereafter, I give her the opportunity to parent the child. My client decided, thankfully, to go to the house about an hour and a half after she left. And from the moment my client opened her car door in her driveway, she heard this little girl, about 1 year old, screaming. She wasn't upset. She was screaming. The photographs entered into evidence show that she had blotches on her face. My client's testimony was that she clinged to her clothing for about an hour after leaving this horrible incident. And still yet, from that moment on, appellant continued down a path of drugs and destruction. And for these reasons, we believe that the trial court correctly found that the mother willfully failed to visit her child. Secondly, we believe the trial court correctly found by clear and convincing evidence that the appellant mother willfully failed to support the child. The test, and again, we're stuck with, I think, with a 4-month time period before mom got incarcerated, June the 5th of 2018. It's undisputed that she paid no support during that time period. The testimony was she bought a couple items of food at some point in 2018, but even if those were during that 4-month period, we would ask the court to consider those as token support.
For interrupting, during the 4-month period, she was employed outside the home. Is that correct?
That is correct, Your Honor. At least at some point, she was employed, I think, where the father was employed at Adient somewhere in McMinn County. And I think the testimony was that she worked 40 hours a week for about a month and made $10 an hour. During no time period did she offer any support. Both of these parties knew where my client lived. They had access to her address. I mean, they're related by marriage. At no point did she send a check, send a money order, anything of that nature. In fact, if we look beyond the 4 months, which I think we need to look at the 4 months, the only time mother was unable to work throughout this entire process would have been during the time period for about a month. She was in the nursing home here in Campbell County, I believe it was, by her own testimony, due to her drug abuse of Opana, which is unfortunately a very addictive and a very deadly narcotic. And she developed, I'm going to try to pronounce this, and I don't know if it's right, endocarditis, I think, and that she testified that was from her own drug abuse. The appellant testified that in sometime in 2016 and 2017, she was working at what's now known as George's here in Campbell County. It's basically a meat factory. They produce stuff, hamburgers and stuff like that. And she testified that she made about $320 a week, and that she gave my client, the appellee, $200 of that. My client definitely disputes that. And in fact, if you look at it, it seems kind of unrealistic that somebody would give over half of their check every week to somebody for child support. And again, we also note that during this time, it seems funny to us that the mother could afford to continue down a path of using drugs and doing things. And she's never focusing on her child. She continues down. Drugs aren't free. You get them from somewhere. And even if she is working, we would certainly contend that she could afford drugs. She could afford to pay child support. The third ground for termination that the trial court correctly found was that the mother's behaviors demonstrate a wanton disregard for the minor child. Excuse me. And the appellant's brief says, well, none of these acts occurred while the minor child was with the mother. That's absolutely correct. But we have to remember that the mother only had custody of this child for 6 weeks, six to 8 weeks after the child was born. And then, my client, because nobody else would step up, my client thankfully wanted to, she filed the juvenile court petition. And so her continued testimony was that she had some rather serious drug convictions. She had an aggravated burglary conviction. She had a theft, which is a felony. She had an aggravated burglary. Like I said, she had a theft under $2,500, which she pled to just last year in 2019.
Counsel, these all were after the birth of the child?
Yes. The first DUI was facilitated just 6 weeks. I believe it was the first one. I'm not totally sure. About 6 weeks after the child was born, which is when the client came into which is, excuse me, when Miss Nelm's client, when the minor child came into my client's custody.
The child was not in the car when the DUI occurred, was it?
That's correct. The child was not in the car. It was staying with a family member.
Did any of mother's actions which are alleged to constitute wanton disregard occur while the mother had custody or was supervising the child?
No, the testimony was that mother did show up to some of the visits high, and her own testimony said that she did. But as far as her convictions that we are aware, none of the convictions that she had were in the presence of the minor child. But as I stated previously, it's important to remember that she only had this child for 6 weeks.
Well, yeah, but we have to think about wanton disregard in the context of harming the child. And if she doesn't have custody or control of the child when she's doing some of these acts, is that really wanton disregard?
Well, even if the court decides that it's not wanton disregard, her failure to manifest an ability to not commit crimes should certainly go toward the best interest, because of the convictions that we talked about.
Agreed. But we were focusing on wanton disregard here, and I'm just trying to work through it.
Okay.
So the event in February of 17, I believe, is that part of the wanton disregard, or is that?
Well, the wanton disregard that we're focusing on is for her criminal acts. But if you look at the totality of the circumstances, which I think we can under the wanton disregard, we're not stuck with a 4-month time period. If we look at the totality of the circumstances, mother done nothing to improve her life. That being said, what's important to note is by mother's own testimony, she states that she still doesn't have a driver's license. And her testimony is that she has to do an alcohol and drug assessment to get that back. She's had 4 months. We want to talk about how good she's doing now, allegedly, but she's had 4 months to try to get her license back to get an alcohol and drug assessment after she gets out of jail. And she still continued to fail to do that. Her own testimony was she has to have an alcohol and drug assessment. You can't get alcohol and drug treatment as ordered by the juvenile court if you don't do an alcohol and drug assessment. The first step in getting help is seeing what you need help with. That's done through the alcohol and drug assessment. And for those reasons, we think that the trial court correctly found or terminated the mother's rights based upon her wanton disregard for the minor child. As we turn to the last issue is the best interest of the child, which as the court knows is very important. And of course, the case law says the best interest analysis is very fact driven. As the court's well aware, the trial court has afforded great weight as it turns to the credibility of the witnesses. And as it turns to the credibility of the mother, the trial court did make a special note as to her credibility, that was called into question because she kept the child on some sort of a EBT or food stamp card for a year after my client had the child. And so we think that. Now, I know the appellate wants to focus on the new Allison case, that the best interest existed, but that case is vastly different in our view than the case at bar. The case, and the main reason is in that case, the mother was shown to have a substantial relationship with her children. That's simply not the case here. In fact, the trial court found that she had a significant relationship with my client, that my client was the only mother that she had ever known, that she called my client mom. And as far as the best interest analysis, the trial court correctly went through each of the 9 factors. And I made a note here that they actually added some factors, which they can do. The child is stable and healthy environment. The child has been with with my client, the athlete, since shortly after birth. My client did initially allow visitation, and she miserably failed at that unsupervised visitation and still failed to change her life in order to exercise this. She never went back to the juvenile court and said, I'm not getting my visits, I'm not doing this. And she never attempted to even have a family member to reach out to my client to say, why aren't you doing this?
Counsel, before your time, let me ask you, trial court found that the mother claimed she'd been free of illegal drug use for a year or so. Did mother present any independent proof at all on that, or was it just her testimony?
It was just her testimony, and she was in a sober living, but it's in court. And I'll finish quickly if I can. Is that okay, Your Honor?
Yes.
That 9 months of this, she was in jail. She'd only been out 4 months. She'd never been in an uncontrolled environment. And so I think that's a big issue. Thank you, Your Honors.
We'll hear from the appellant rebuttal.
Thank you, Your Honor. I do want to address one thing. You asked me if there was, if the trial court made a finding that there had been no proof presented of a clean drug screen, and I think that is a finding. However, I think it's paragraph number 5 in the findings of facts of the trial court's order. However, Ms. Davis on page 40 of the transcript from, I think it's volume 1, but it's from November 15th, 2019, states that my client did hand her a drug screen. She didn't accept it, but she did present her with a drug screen. And I'm going to bounce around a little bit, but I want to hit on a couple of things. There's no question that my client has struggled with drug addiction. That's just the bottom line. She was in a cycle, but she has worked her way out of that cycle. She's not going to get from point A to point B overnight. That's just not possible. But she testified that she was, with regard to whether there was a drug and alcohol assessment, I think that happened. I don't think it's in the record, however, but regardless, she testified that she had to be tested by her probation officer or as part of her probation, and that she had not failed those drug screens. She had to be drug tested as part of living in the home that she was living in. Those were separate drug screens.
Counsel, I mean, did she provide any proof of this other than her testimony?
I don't believe there were any specific drug screens that were introduced into proof, Your Honor.
Well,
but
was there any proof presented other than her testimony?
Yes.
On that issue that she'd been clean and sober for this period of time?
There was testimony, Your Honor, from my client's aunt, Melissa Fugit, who helped care for Hadley. There was testimony from her grandmother, Patricia Corner, and there was testimony from her cousin, whose first name escapes me at the moment, Mandy Fugit, I believe. All of them testified. They've known my client throughout her lifetime. They watched her go through this drug addiction, and they all testified about how she had changed. Now, obviously, they can't testify, here's what her drug screen says. They're not capable of doing that. But they testified to what they had observed of her, and her behavior was totally different from the time she had been released from jail in the summer of 2019 up until the time of the trial. They all talked about that. She was responsible. She was working. They could rely on her, that she was a different person than who she had been. So there was that testimony. Counsel brought up the Henry Allison P case, and we did cite to that case. And I do think it is provides some guidance to the court, though, again, every case is based on its own unique set of circumstances. And in the Henry Allison P case, the mother had been given the opportunity to maintain a relationship with her child. That's not the situation here. Ms. Davis did not allow that. And nobody's saying Ms. Davis should allow my client to see her child if she was under the influence, but that's not the totality of the proof here. And the case of Henry Jonathan states that interfering with attempts to maintain a relationship may render the best interest factors inapplicable. Even though a parent may have exhibited wanton disregard for a child's welfare. Here, I think, is the bottom line. These cases, when you read them, they're heartbreaking. And I don't see all the facts of them. I just see I guess the sanitized version of them with what gets published in the court's opinions. But the reality of it is that's not the situation that Hadley's been in. My client recognized that she needed assistance with Hadley very early on in Hadley's life, and that's why she agreed for Miss Davis to care for the child. Hadley was never in a situation. She was not in the car when Miss Bowman was in the accident, when the DUI. Hadley was not in a situation of abuse. That's just not the facts here. And it is in her best interest to be allowed to continue with a relationship with her mother. And that's why we're asking the court to overturn this termination of parental rights. Thank you.
All right, thanks to counsel for both sides. We appreciate your briefs and your arguments on this. Mr. Hivner, if you'll adjourn court, or excuse me, recess court until our next case.
This honorable court is now in recess until 10 a.m.